Just waiting. Again, we apologize for the disruption. We were notified by the San Francisco Police Department that we needed to adjourn the meeting. There was apparently a security threat that has been found not to be credible. So that's why we're back, and that's also the reason why we initially adjourned. So we are back in session. Mr. Mayor, I caution you that you're still under oath. I believe when we left off, there was a question pending. Mr. Kopp, would you like the court reporter to reread the question, or would you like to ask a question?
I have no idea what the question was, so it'd be great if we could get it read back. Because that's never happened to me before.
I don't think you're alone in that regard.
Okay, and would you agree with me that one of the things that is expected of elected officials is for them to be honest and forthright when dealing with not only their constituents, but with other elected officials?
Thank you. And there was an answer?
No, there was no answer.
Then, Mr. Mayor, if I could ask you to answer that question.
Yes.
Okay. And when you became mayor, you told everybody you were not going to run for election. You were going to be a caretaker mayor, and you were then going to leave office, correct?
Objection, relevance, argumentative.
Sustained.
Well, may I be heard on this?
You may.
If one of the things that is expected of public officials is honesty to constituents and other elected officials, and if that falls below the level of decency, I think that's relevant to this inquiry if this particular witness has fallen below that level.
My view is that the mayor's conduct is not at issue before us as far as whether or not his conduct fell below the standard required by 1505.
Okay.
That's why I think it's irrelevant.
Okay. Now, Mr. Mayor, you've given some public statements about the reasons that you filed these charges, right?
Yes.
Okay, and you've spoken to some reporters, right?
Yes.
And you have told at least one reporter that the reason why you think the sheriff should be removed is because he beat his wife, right?
Yes.
Okay. Upon which facts do you base that assertion?
The court records and his admission of guilt.
Well, the sheriff has admitted that he grabbed his wife's arm in an argument and left a bruise, right?
He admitted to domestic violence.
Okay.
And he caused the bruises on his wife.
Okay. Do you see a distinction between grabbing someone hard enough to leave a bruise and striking them, perhaps with a fist?
I believe he caused bodily harm to his wife, and that's what the basis of the facts are in his plea.
Okay. And to you, that's synonymous with beating his wife?
Yes.
All right. Now, do you think that it falls below the standards of decency and right action expected of elected officials if you have an affair with a subordinate who happens to be married to one of your good friends?
Relevance. Objection, relevance.
Sustained.
Does it fall below the standard of decency and right conduct expected of public officials to strike your spouse with a glass?
Objection, relevance, calls for a legal conclusion.
That one I'll overrule.
I'm not sure I understand the question.
Please, again, instruct the sheriffs. If we hear any outbursts, I want that person removed. Thank you. Yes, I'm speaking to you. If I want you to be observing the crowd. If anyone makes an outburst, and I understand public, trust me, I understand that there's an urge to have a physical reaction, but we really do need to keep silent. So please remove them if there's an outburst. I apologize, Mr. Kopp.
No, that's fine. Let me see if I can explain. You're aware that there were allegations that the fire chief struck her spouse with a glass, right?
I read some allegations in the newspapers.
Okay. Were any steps taken to remove her from office?
I don't know.
Okay. Would that fall below your definition of the standard of decency and right action?
Objection calls for legal conclusion.
Overruled.
I don't know what you mean by that, because I don't know all the circumstances around that, and I don't believe I was mayor at the time.
Okay. Now, in your initial filing of written charges of official misconduct, there was no mention of the sheriff doing something improper with the way that his firearms were turned over to law enforcement, correct?
Objection, foundation.
Overruled.
There is declarations from the police department that indicated that there was less than full compliance with the orders of the court.
And you didn't make note of that in your original written charges of official misconduct, right?
Objection, foundation assumes that the mayor wrote those charges.
Okay, well, why don't you lay the foundation about what was in the charges? Sustained.
You originally caused written charges of official misconduct to be filed against the sheriff, correct?
Yes.
Now, presumably you read those before you filed them, right?
Yes.
Okay. So you know what was in the original written charges, right?
Yes.
And there's nothing in the original written charges about the sheriff doing anything improper with relation to the getting of his firearms into police custody, right?
I don't recall originally, yes.
Okay. And in fact, you don't believe that to be a sufficient basis to remove the sheriff from elective office, right?
Objection, argumentative, lacks foundation.
Overruled.
Are you speaking to that just being the sole charge?
Yes. If that's the sole charge, do you believe that that is sufficient to remove an elected official from office?
Irrelevant, objection.
Overruled.
In and of itself, I do not.
As a matter of fact, in your filing of written charges, you have confined yourself to the incident between the sheriff and his wife on December 31st, as well as allegations that the sheriff may have been involved in attempts to dissuade witnesses, right?
Objection. Do you have a document you'd like to put in front of the
No, I'd
mayor
like to ask the witness a
sorry.
question.
I'm sorry, do you have a document that I didn't hear?
that you could put in front of the mayor?
Okay, what is the basis of the objection, the legal basis?
I think he's misrepresenting the document, and I think it would help the witness to be able to see the document rather than be quizzed by memory.
I
don't have one word for that, sorry.
I think the question was unclear. I would ask that you rephrase it.
Okay. Let me ask you about your claim that the sheriff engaged in witness dissuasion. You're familiar with that claim, right?
Yes.
And in fact, in the original written charges of misconduct, the only thing that you claimed was that he may have been involved in witness dissuasion, correct?
I'm not familiar. I can't remember the exact wording, but I understand the issue, yes.
Okay. In the amended charges, you now say that he did engage in witness dissuasion.
Yes.
All right. And what is the information that you learned since the original filing of the charges and the amended charges that caused you to make that definitive assertion?
Objection, attorney-client privilege, and assumes facts not in evidence.
Can I have the question read back?
All right, and what is the information that you learned since the original filing of the charges and the amended charges that caused you to make that definitive assertion?
I'll hear argument.
Well,
On the attorney-client privilege.
I would limit it to information he got from sources other than his lawyers.
With that stipulation, the objection is overruled.
So just to be Could Mr. Kopp restate the question with the limitation,
Yeah,
please?
let me see if I can re-ask it. Without telling us anything that you learned from your lawyers, can you explain what is the basis for your assertion that the sheriff engaged in witness dissuasion?
The review further of the declarations or the statements that were reflective of the videotape and the declarations of the particular witness, Ivory Madison.
And is it your assertion that Sheriff Mercarimi somehow dissuaded Ivory Madison from speaking with the police?
I believe that he was part of the effort to not have people talk to the police department, including his wife.
Okay. And what do you base that belief on?
The declarations, not declarations, but the transliteration of the videotape.
And when you say the videotape, you're talking about the 1-minute videotape that Ms. Lopez made with Ms. Madison?
Yes.
Okay. Are there any other facts that you base that assertion on?
Objection, attorney-client privilege.
Excluding conversations with your counsel.
Conversations with your counsel.
With that limitation, the objection is overruled.
The declarations of Ivory Madison.
All right. Now, you have stated in your declaration that one of the reasons that was significant to you that this was official misconduct is because a law enforcement officer must follow the law and enforce it, but Sheriff Mercarimi pled guilty and was convicted of a crime. Is that right?
Yes.
Okay. Is it your belief that any time a law enforcement officer is convicted of a crime, that constitutes official misconduct for which they must be removed from their employment?
I believe that it is significant that being the sheriff of the city that engaged in and was convicted of and pleaded guilty to domestic violence is the wrongful behavior that constitutes official misconduct.
Okay. Let me ask you, what if a deputy sheriff gets convicted of a crime? Must they be removed from office?
If it is similarly situated in similar circumstances, that would probably be the conclusion.
Okay. And if you discovered that there were deputies within the San Francisco Sheriff's Department who were similarly situated yet were not terminated, would that change your opinion?
Not necessarily.
Okay. You also say that because Sheriff Mercarimi was sentenced to time served in county jail and the sheriff is charged with overseeing prisoners in the jail, that somehow constitutes official misconduct, right?
In the context of all the actions, yes.
Okay. And you are aware that, in fact, this was a book and release procedure where the sheriff surrendered, posted bail, and was immediately released, correct?
I'm not aware of any difference of being of his arrest and any other arrests. It is still an official arrest.
Okay. Are you aware that a former sheriff of San Francisco actually spent 5 days in jail on a criminal contempt conviction and was not removed?
Objection, relevance.
Sustained.
Was it your belief after you reviewed these court records and the records, well, strike that, I'm sorry. After you saw that Sheriff Mercarimi had pleaded guilty to the misdemeanor, false imprisonment. Did you do any additional investigation before you brought Sheriff Mercarimi in to talk to you?
Yes.
What did you do?
I reviewed all of the court records that were available at the time from the court proceedings.
Okay. Did you seek to speak with any witnesses to that case?
Objection, deliberative process privilege in terms of who the mayor spoke with in regard to the case.
Mr. Kopp, you did ask that question earlier.
I'm not asking for the name.
It. You're asking, did you talk to anybody?
Did he seek to speak with any witnesses? And I can narrow it.
Okay, I think the did you talk to any witnesses is okay. Overruled. You may answer, Mr. Mayor, if you recall.
Yes.
Which witnesses?
Ivy Madison.
Objection.
Answer,
Did you talk to Eliana Lopez?
Same objection. The deliberative process privilege applies in terms of who the mayor consulted with when making high-level policy decisions like the discretionary decision at issue here.
Mr. Kopp, response?
I don't have a response because I haven't had a chance to research the deliberative process privilege because it appears to be common law and not statutory. But the mayor has discussed talking to Sheriff Mercarimi and not anybody else. So, I mean, I think that is fair game here.
Okay, where does he say that?
In paragraph 6 of his declaration, I met with Sheriff Mercarimi, spoke with him, and gave him an opportunity to resign.
Where does it say he didn't speak to anybody else?
Well, I think that's inferred from the lack of mention of him speaking with anybody else.
Mr. Embledge, do you have any insight into whether the deliberative process privilege would apply here?
The deliberative process privilege has been, as Ms. Kaiser stated, applied by the California Supreme Court as to Governor Duke Majan and who he met with in making policy decisions. Certainly that would be a useful analogy. I'm not aware of any reported case where the deliberative process privilege has been applied in a situation where charges were filed against someone, but I'm not sure that's an important distinction.
Does it matter that the people that the sheriff is asking about are not other officials, but just lay citizens?
No. In the Duke Majan case, it was a request by the press to examine his appointment book, and the issue was he should be free to meet, the governor should be free to meet with whoever he wants to meet in order to make a policy decision outside or inside the government.
Does the privilege attach to the witness who spoke to the executive? In other words, does Ms. Lopez have, she's not bound by that privilege?
Not that I'm aware of. I'm not aware of anything extending the privilege in that manner.
Okay. Do any of the commissioners have views on this? Ms. Kaiser?
I would like to address the waiver argument, which I have not had an opportunity to speak to before. There is case authority for the proposition that unlike attorney-client privilege, or usually it's attorney-client privilege where you tell part of the story and you've opened the door to full disclosure, that is actually not the case with deliberative process privilege. It is possible and desirable for an official to be able to discuss what they did in terms of reaching a decision without having then to disclose everything they did and everyone they spoke to. So the case law has held that there is no waiver simply because you've disclosed something about the decision-making process that you went through. So the mayor is entitled to disclose what he has disclosed without being compelled to then discuss the names and identities of everyone he spoke to while making the decision. And the case authority for that is Blue Lake Forest Products versus United States. It's 75 Federal Claims 779-791. It's a 2007 case.
Do you have anything else to say?
It's a little hard to research this on the fly. My apologies.
I'm going to sustain the objection.
Let me ask you this, Mayor Lee. You met with the sheriff and asked him to resign, correct?
I did meet with the sheriff, yes.
And when the sheriff came to meet with you, he came with a lawyer from the sheriff's department, right?
I believe he did come with somebody, yes.
And you decided that you didn't want to have that person present, but you wanted to meet with the sheriff one-on-one, correct?
Relevance? Objection?
Overruled.
I asked him if he would come in by himself to talk with me.
Okay. And when you spoke with him, did he offer to make his wife available to you so that you could speak with her before you made any decision on this matter?
I don't recollect the exact words, but I believe he made some assertion in that direction.
Okay. Offered you her phone number if you wanted to speak with her?
I don't recall that.
Okay. Did you ever speak with Ms. Lopez?
No.
Okay. And that's because when you brought the sheriff in, your mind was made up. You were going to give him a choice, either resign or we'll file the written charges.
I had determined what direction I had. I gave him an opportunity to come meet with me and talk with me. We did. And had an opportunity to tell him what we were going to do and also give him some time to think about it.
Well, one day, right?
Yes.
Okay. And so is your testimony that when he came to meet with you, you had an open mind about what you were going to do? That is, if the sheriff could persuade you that this conduct didn't warrant him being removed from office, you might not have done that?
I was open to listening to him, but I was also clear that I wanted to indicate to him what I was considered doing.
Okay. So as of the day before you filed the written charges, you still had not decided what you were going to do?
Objection, misstates testimony.
The witness can clarify if that misstated his testimony. But you may answer if you can. Do you have the question in mind? Yeah. Can you read back the question? Or do you want to ask?
I'll try to re-ask it. You had two meetings with the sheriff, and one was on one day and one was on the very next day, right?
I had one meeting with the sheriff, and then I had another conversation with him on the telephone.
And were there not two meetings that both took place in your office?
Objection, vague.
Sustained.
Isn't it true that you met with him on two successive days and both meetings were in your office?
Objection, vague.
Do you understand, Mr. Mayor, what he's asking?
I don't recall having two meetings in a physical meeting with Mr. Berkenbremy at the time.
Okay. So your best memory is that the first meeting was in person in your office, and the next time you talked to him was by telephone.
That is correct.
And it was on the second time that he told you he was not going to resign, correct?
That is correct.
Okay. And at that point, you had decided that you didn't think Sheriff Mercury was fit to be employed by the city of San Francisco, right?
I had, at that time, come to a final conclusion that he had conducted himself with official misconduct and he had engaged in a wrongful behavior and came to that conclusion.
Okay. Did you ever extend an offer through third parties that if he would just resign, you'd find him another job in the city?
Objection, relevance.
Mr. Kopp, where are you going with this line?
Credibility. If he didn't think he was fit to be sheriff, why would he think he would be fit for a city job?
Ms. Kaiser?
I would continue to object on the basis of relevance, and I also don't think it goes to bias. Many times there are problems that people try and resolve with compromise, and that does not mean that they don't believe that there is an actual problem.
I understand your objection. That the mayor, though, has put at issue the reasons why he suspended the sheriff in his declaration, and I do. It's pretty close to the line, Mr. Kopp, but I do think, given that basis, it could arguably go to bias. So it's overruled.
I don't recall offering Mr. Mercarimi any job.
So you never authorized, say, Aaron Peskin or Walter Wong to convey to Sheriff Mercarimi if he would step down, you'd give him another job?
Absolutely not.
Okay, thank you. I have no further questions.
Thank you, Mr. Kopp. Ms. Kaiser, do you have any redirect?
Yes, I do. Thank you. Good afternoon, Mr. Mayor. When you said that the sheriff beat his wife in a recent interview, as you just discussed with Mr. Kopp, did you make a distinction in your mind between a little domestic violence and a lot of domestic violence?
No, I did not.
Do you believe there's such a thing as just a little domestic violence?
No, I came to the conclusion he did commit domestic violence. He admitted to it, and that's the conclusion I have.
Why did you not call Eliana Lopez?
I did not believe that discussion with her had anything to do with the decision that I was responsible to make with respect to official misconduct.
Why not? Why did you not need any further information from her?
Because I believe that the record that was established through the court, the criminal actions that were confirmed, the plea of guilty, were enough to define the wrongful behavior for official misconduct.
So is it fair to say that you relied on his guilty plea instead of calling his wife?
Sustained.
What was the main criterion in your decision, if there was a main criterion? What was your main criterion when you reviewed the record and the information that you had and decided that there was a reason to state a charge of official misconduct?
The question I had is whether he actually did engage in criminal activity, that whether he had perpetrated domestic violence on his spouse, and whether, and as I read it, he admitted to a false imprisonment.
What convinced you, if anything, that he had actually done these things?
Primarily his plea to that charge, and the acceptance of the sentencing that goes with it.
Did you understand his guilty plea to be an admission on his part that he actually did what was charged and what he pled guilty to? I'm asking about his understanding.
But it's a form objection. I'll sustain it. Can you just rephrase?
What, if anything, did you understand the plea that he entered of guilty to mean about his actual culpability?
That he was the one that admitted to being guilty of the charge of false imprisonment, that is domestic violence, and that he caused the physical bruising on Ms. Lopez's body.
Do you have an understanding, Mr. Mayor, or an expectation of the relationship between a guilty plea and factual guilt?
Objection, that's beyond the scope.
Overruled.
Guilty plea is, in fact, the admission of those facts that support that allegation.
So You've been criticized for not calling Eliana. Why? You've also, it's been noted in the sheriff's declaration that, and elsewhere in public, that you did not complete a full investigation before you brought charges. Is there a reason why you were prepared to bring charges when you did?
Counsel's testifying.
Overruled.
I waited for the whole criminal prosecution to complete itself. And as I said earlier, out of respect for Mr. Merguimi's rights as well as the judicial process, I waited for the full conclusion and then asked to make sure that I had the complete record and reviewed what I could in order to make that determination.
Was there any reason why you didn't then also conduct your own full investigation?
I believe that the court process established the facts and the plea, and that was sufficient to confirm the wrongful behavior.
Why didn't you suspend Sheriff Merguimi with pay?
I believe that that position requires someone who is working in order for the city to pay that person. And if that person is not permitted in this case to work, and it was a result of these circumstances that I felt it necessary to suspend without pay.
Well, why didn't you treat him as innocent until proven guilty?
Because he had already pleaded guilty to this charge, and the court confirmation of this is its conclusion.
You mentioned, well, Mr. Kopp mentioned, and you agreed earlier, that there are some political issues between you and my boss, Dennis Herrera. Is he your political ally? Was he in the last, maybe I'll withdraw that. Was City Attorney Dennis Herrera your political ally in the last election?
I don't think so.
Are you planning on suspending Dennis Herrera and bringing charges of official misconduct because he was not your ally in the last election?
Sustained.
Mr. Mayor, do you think you're more prone to bringing official misconduct charges against people who are not your political allies?
Overruled.
No.
A sheriff is a department head in San Francisco, is that correct?
Yes.
Is there any department head of any department who could plead guilty to domestic violence and not be removed for official misconduct?
You asked the same types of questions. I'll overrule that.
I would find that would be a serious enough charge to fulfill official misconduct, certainly wrongful behavior.
Any department head?
That's correct.
Okay. Did you have any special concerns of any sort that the department head in question who had pled guilty to a charge of domestic violence was the sheriff?
I think there is added significance because the sheriff is one of the top two law enforcement positions in the city.
Can you say more about how that is significant in your view?
One of the more disturbing aspects of this is my knowledge that the sheriff is in charge of responsibilities with respect to domestic violence victims, and that it has historically been a very strong program in the city of San Francisco, shared by several various departments to do their part to prevent and to respond to and to encourage witnesses to come forth in an effort to end domestic violence. And that the Sheriff's Department is a key to those various agencies that have that responsibility. And for the Sheriff himself to be confirmed as engaged in this is significant.
Do you believe you should lead by example, Mr. Mayor?
Yes, clearly.
Do you believe that part of leading by example is showing the power of redemption?
That's certainly something that I've learned, particularly as applied to domestic violence.
Couldn't you model redemption by dropping the official misconduct charges against Sheriff Mercarimi and giving him a second chance?
I came to the conclusion of official misconduct because I believe that the actions that were admitted to and the crime that was perpetrated has to have direct consequences. And I believe strongly that a direct consequence is that you cannot be sheriff of the city if you are guilty of domestic violence.
Do you think, as you sit here today, that the sheriff is ready for a second chance from you as the decision maker?
Objection, relevance, speculation.
Sustained.
Mr. Mayor, does the sheriff have any duty to work together with the mayor?
Yes.
In light of the events that have transpired since you brought the official misconduct charges and the discourse that has been in the, well, let me back up. Are you aware of any statements that have been made about you in the press by the sheriff or his attorneys? I'm laying a foundation.
I'll allow that. Overruled.
Some.
Have they been friendly assertions?
I don't believe so.
Are they the sorts of assertions that you believe you could get past and rebuild a relationship with the sheriff so that you can work effectively together if he's reinstated?
It'd be extremely difficult.
One last question, Mr. Mayor. In terms of official misconduct charges, are you the decision maker in the process, the ultimate decision maker about whether the sheriff should be removed?
I'll allow that. Overruled.
I am not.
So are your conclusions and your beliefs, as you understand this process, to be the final word on whether the sheriff has committed official misconduct?
No, I have brought the charges based upon the facts that I've seen, and I know that it is the ultimate responsibility of two additional bodies to confirm that.
So as you understand it, does this case rise or fall in any way on your opinions?
Objection, relevance.
Overruled.
It does not.
Thank you, Mr. Mayor.
Briefly, Chairperson.
Yes, Mr. Cobb,
Chairperson.
please proceed.
So, Mayor Lee, you said essentially that your feelings have been hurt by some of this stuff, and you'd find it extremely difficult to get past that and work with the sheriff.
Objection misstates testimony.
Please rephrase. That's
All right.
objection sustained.
Mayor Lee, you just testified that based on things that have been said during the course of this proceeding, you would find it exceedingly difficult to work with the sheriff if he remained in office, right?
That's correct.
Okay. Let's say this process concludes and you don't have the votes in the Board of Supervisors and the sheriff remains sheriff. Are you telling the commission that you will refuse to carry out your duty to work with the sheriff?
I'm not going to refrain from any of my duties, as I haven't up to this time. I will continue carrying out my duties, if that's
Right.
what you mean.
And if these removal proceedings do not result in the removal of Sheriff Mercarimi, of course, you will put aside your feelings and do what's best for the city and work with him, right?
Yes.
Just as you put aside your differences with Mr. Herrera and you're working with him, right?
Yes.
Thank you. Nothing further.
Do any commissioners have questions for the mayor? Mr. Mayor, thank you for your time. You are released.
Thank you.